Supreme Court. This is the final court of appeal in the English judicial framework. This handles cases from the Court of Appeal, the Divisional Courts, and, on certain times, directly from the Supreme Court under the so-called leapfrog rules. Appeals shall be heard by the Supreme Court of Judges. We will serve in an unequal jury, meaning that there could be 3, 5, 7, or even 9 judges waiting to consider the appeal. Permission to appeal. The appeal from the Court of Appeal or the Divisional Courts must be issued leave to appeal to the Supreme Court. This authorization can be given either by the Supreme Court or by the lower court. It is challenging to seek to leave to appeal. For example, figures for 2011 indicate that in just 48 of the 171 cases, leave to appeal to the Supreme Court has been issued. In leapfrog cases filed by the High Court under the Administration of Justice Act 1969, not only does the Supreme Court give leave to appeal, but the judge must also award a certificate of satisfaction. That can only be achieved where the situation addresses a question of law of general public interest, which either requires the reading of a rule or is one where the judge is constrained by a prior ruling of the Court of Appeal or of the House of Lords/Supreme Court. It will mean that an appeal to the Court of Appeal would have little effect, as it would already be bound by the prior ruling. Leapfrog's appeals are unusual, with leave to appeal being obtained in just 2 to 3 instances per year. However, if the requirement for permission to appeal has been met, there is a very strong probability in civil litigation that the challenge will be accepted. More than half of the cases currently considered by the Supreme Court were effective in 2011. The number of appeals considered by the Supreme Court is limited, typically about 60 cases a year concerning civil law, with around 3/4 of them requiring legislative interpretation.